What's up, everybody? So I had a chance this is Robert Kraft from Our United Republic. So I had a chance to get a hold of a dismissal on a case that I'm giving lawful counsel, right? Because our Constitution and our Bill of Rights say that you're allowed to have that. And we are allowed to talk about our Constitution, our Bill of Rights, and actions at law whenever we choose to. So I got a hold of a motion to dismiss on a gentleman. Let me give you a quick background. This gentleman, he filed for a declaratory judgment of fact at common law in the county court, Charlotte County, Florida. All he wants is a few questions answered regarding whether roads that do not have MSBUs or roads that do not pay taxes are actually public or private, and whether they can have public access right-of-ways. So Charlotte County government, he already tried their internal system, and they basically gave him the runaround, $3,000 they took from him, and then they did whatever they wanted anyways. And their excuse, apparently from what I've been advised, is that they have thousands of roads in Charlotte County, Florida, that they don't want to update and they don't want to have declaratory judgment on, because then they would actually have to do their job. So he filed a common law case, action at law, and he wants a jury to decide what the definition of these roads are. And now they are filing a motion to dismiss. And it's interesting what they actually said in this. Now, I want you to remember who is saying this. This is Charlotte County government in Florida, the political subdivision of the state of Florida that emanates from the seat of government that comes from Tallahassee, which is the seat that has carved out Charlotte County, Florida in 1921 by law. Okay. We need to understand these terms because at common law, we're dealing with territory law. We're not dealing with legislative law. We're not dealing with statutes. They have statutes, and their job is to follow their statutes because that's how they actually get their power. We, the people, had the power before the government was birthed, and we have the power after. So if you read the Constitution, it says we, the people. If you go to the 10th Amendment of the Bill of Rights, it says all powers deemed not bestowed to the government are remanded back to the state or the people. So the people are the beginning and the people are the end, and anything in the middle is what we allow or we consent to or we object to. All right. So we're going to run through this. I'm going to share my screen and we're going to get started. There's 9 pages here, and we're going to pull apart exactly what they're doing. So give me 1 second. Sorry. Apologize. All right. So this is the first page, and this is what we have. So we have the top of the first page. This is called the header. Now I'm going to show you something really important that you're going to need to know when you're starting to go after them or hold them accountable. Technically, this gentleman has not actually processed this document correctly, because right here, there is supposed to be a line that runs across this. And if you look up a styles menu, that styles menu will tell you there's supposed to be a line here. The reason there's supposed to be a line here is because on the outside of the box, this is actually the header that you would actually get. All right. So this is the header. This is the technical preamble of the case itself. It has no declaration, but it gives full identification. All right. But there's some problems in it. Number one, the petitioner filed in the county court in and for Charlotte County, Florida. Okay. This county attorney, this is a public officer, by the way. Not only is he a public officer by way of the fact that he's sworn an oath to the court, right? He signed an affidavit of oath that he would uphold the Constitution, he would uphold the Bill of Rights, and all this other stuff that he's clearly in this document defiling, which technically could be construed misrepresentation of the public, treason, plus a bunch of other things. And he actually admits it, which is great, because this was exactly what we need to do. We need to get them in a place where they show us exactly what they're doing. So let me explain what's wrong. So this should be in the county court in and for Charlotte County, Florida. But what he actually filed his header in is the circuit court. And the circuit court is a equity court. The reason it's an equity court is because it is a birth child of legislation. In other words, it doesn't come from common law. It comes from legislation under Florida Statute 26. Now, something you need to know about statutes and laws. So you have legislative acts, right? Legislation, because this is exactly what we're going to get into in this. So we have legislation. I'm just going to put right? And we have statute. Okay. So legislation and statute are for government. Okay? So see if I can get that going better. All right. Common law. Why are you doing this? This thing's acting strange today. Common law is the people. The reason is because the people consent and then give government their power, right? It's our consent or objection. That's how it's written. All right. So the 20th Judicial Circuit, is actually a birth child under Florida Statute 26. Now, county courts, right, which is where common law is, because that's territory court, county court. Why are you doing this today? Let's see if we can get this thing working right. Whoops, look at that. Screwed it up. Okay. So county court, right, is territory court because it has survey lines. So you want to be in county court. So what he's doing is, now he doesn't understand probably this because he is a equity trained or equity educated attorney. Okay. So because the equity educated attorney, he doesn't understand common law at all. The reason he doesn't understand common law at all is because we should have technically been common law lawyers, or at least really close, because we have a republic by the time we graduated high school. And you weren't allowed to graduate high school in 1700 unless you could have a public debate. So he may not know, or he might know, and he's doing it on purpose. But the way that he acts in this is reprehensible for a public officer. And that's something that really needs to be addressed. Okay. So, and that's why we're doing this. All right. So now, let's see here. All right. Look at that. Stuck to it. I like it. Perfect. So here are some problems here. Now, remember, this case came forward at common law. The judge or the court has already received a copy of the Florida State Rules of Common Law and the court order from the Florida State Supreme Court. So they're fully aware that this is at common law, and they're fully aware that they have the rules. We are going to follow up on that a little bit, but in essence, they should already know, and petitioner has the right to choose battlefield. Okay. So Charlotte County's motion to dismiss for complaint of declaratory judgment. The defendant, Charlotte County, a state of Florida political subdivision. So let's go right here, right? State of Florida political subdivision. Yeah, buddy. Thank you. So he just admitted that he is of the state of Florida. Now, if you read Aristotle, you'll find out that the word of actually means slave to. That's why it's the United States of America. And this comes from Aristotle. Okay, so because remember, all philosophy is where Aristotle, right? So that comes from Aristotle. So he's admitting, I admit that I am a slave to the state of Florida. Okay, or here we go, the people of the state of Florida. Yes, we already know that you are a slave to the people. The problem is you are not being a good, obedient servant. You are being a reprehensible, defiled little puppy who needs to be put in your place. So, right here, next problem. We are operating at the rules of common law. Civil procedure falls under equity or admiralty. So he's citing the wrong rule, right? Because this is a action at law. Make sense? I hope so. Okay, so let's get down to this thing. Plaintiff has filed a petition, declaratory judgment to ask. Now remember, we're asking the people, right? So right here, it says, so declaratory judgment, right? Which is really what we're trying to determine is a fact. Now this is why they don't want it. A fact comes from the 7th Amendment, where no fact determined in trial by jury can be reviewed by any court of the United States of America. Remember, of slave, of the United States of America. So the court is of the United States of America. So the court is the slave of the United States of America, except at the rules of common law. That's right. That is what your Bill of Rights says under the 7th Amendment. Okay, so we are asking for a declaratory judgment of fact, because the fact is slave to the judgment. So we want 3 questions answered. Is Prada Street a private road? Is Prada Street a public road? Can a road or street not paid for by public taxpayer funds and or MSBU be deemed a public access right-of-way in Charlotte County? Okay. And then he asked for an order too. So the order is, so let's talk about the order real quick, because the order is, because it's a fact, if this goes the way it's supposed to, the fact will be, is Prada Street a private road? Yes. Is Prada Street a public road? No. Can this happen? No. Okay. But now what's actually happened is we have what's called a general common law. This is the law of the land from this point forward. And the order is to command the defendant to update and notify records, date records. That's right. You now have a court order telling them, no, 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 yes, no, no, and go update your records. That's why they don't want this, because this is actually a command. All right, so we're going to go on to page 2. Page 2 coming up. It's very interesting. Okay, here we are, page 2. All right, let's see what we got. There does not exist any controversy. So what he's saying is, and he's actually contradicting himself. The defendant, which is the county, does not see a controversy. Yeah, we don't see anything wrong. But this is a petition of right and an action at law, and the plaintiff decides if there's a controversy. So what he's doing is he's trying to tell you, you are not allowed to have a controversy unless we say so. Slave. Petitioner has no standing to bring case for declaratory judgment. No standing, right? So what this means, what this is standing, right? You have no standing. Well, unfortunately, standing is a term for equity. That's right. Your circuit court, not territory court, because the only standing he needs is a grievance under the First Amendment and to file a petition. Oh, wait, hold on. That's called petition your government for redress of grievance. So this guy, your public officer, by the way, who gets paid taxpayer funds and is sworn an oath to this thing we call the Constitution, is actually telling you, well, unless you have a right, you can't say anything to us. We can do whatever we want. Now, little does he know, if we want to make another argument, this gentleman who filed the petition, it's his road. And not only is it his road, but Charlotte County government charged him $3,000 to give him a dog and pony show, basically defrauding him out of $3,000. So there is definitely a controversy that is going to get dealt with now that we're in the right court. Now, here's the best part. Legal argument. So he is making a legal argument, which unfortunately this case came at law. And a legal argument comes from the word legalese, which means equity. And it means admiralty. And it means business or commerce. Law, well, that's the law of the land. That's the Constitution and the Bill of Rights at common law. That's why they call it common law. Look at that. Law. That's right. And the law will catch you. And that's what's happening here. So, petitioner has failed to lay out a minimum requirement for declaratory relief. Well, let's just hit the elaboration on this one. Here's his failure. This is what the puppy thinks, right? You failed to lay out a minimum requirements. Hold on. Here. American people instruct government. Boom. There. Minimum requirement. Done. Okay. A viable complaint. So now they get some judge or some court says whether you can actually file a petition, which I believe that would be a First Amendment issue, right? Okay. And declaratory relief. I didn't ask for any relief. I asked for a fact. There's no relief here. Just facts. At a minimum, there is no bona fide dispute between the parties. The plaintiff has a justiciable question. The plaintiff has a justiciable. So this is the word justice, right? Justice. Oh, and justice is not equity, by the way, just so you know. As to the existence or non-existence of some right. Some right. Oh, you mean the Bill of Rights? Apparently, immunity, power, or some fact upon which the existence of some claim may depend. Such a claim may depend. Claim, yeah, your right, your rights, your Bill of Rights. Rights are property at common law. That's right. Rights are property. Here's why. Now, let's talk about the case that he's citing. See this case? See that case right there? That's beautiful. That's wonderful, right? This is the Southern 3rd District of Florida, right? Because we're in Tampa, right? 3rd District, right? And then this is the 2nd District Court of Appeals over in Lakeland, right? Here's the problem. Equity. Look who he cited. Oh, look, he cited a pension fund, which is money, right? So police officers are trying to deal with a pension fund for firefighters, right? Via the Board of Trustees pension fund for firefighters and police officers. Yeah, he's right. The case is about money, not law. And money and law are two different things. Secondly, the Southern 3rd, right? Southern 3rd pension fund. Okay, that's great. This is a court of the United States, and the 2nd District Court of Appeals is a court of the United States, which means in this case, there was no trial by jury for a fact. There you go. He's literally telling it to you. Boom. So, wrong case. All right, we're going to come on up. All right. The petitioner does not provide any required. Petitioner is not, hold on. There we go. Okay. Petitioner does not provide any required, right? Oh, sorry, we're gonna keep on black. Oh, okay, there we go. Provide any required components to request declaratory relief. So apparently, Mr. Public Officer Agent Attorney Ternan Clowell actually believes that to exercise your First Amendment to determine a fact, a trial by jury, you have a requirement. And you're not allowed to use your court. Not allowed. Go away, Swan. There you go. That's what he's saying. There is no bona fide dispute between the parties, nor is there a question regarding the existence or non-existence of any rights. Nor is there a question regarding the existence or non-existence of any rights. Here, hold on. Yeah, the ones that came down from heaven. Bill of Rights. Who gets those? Who gets those? But this guy's saying, you don't have any rights. And there's no dispute, right? So this is the arrogance. Now, believe it or not, this kid, well, I've met this kid before, this attorney, right? Boy, he's a scared little puppy, terrified. But he should be, because when the hammer drops and thunder goes haywire, he's just going to be told, yeah, you like did all this stuff, and you're responsible now. And he's going to wonder why, because nobody's going to come help him. So petitioner is not entitled. Look at this, not entitled. You are not entitled to declaratory judgment within it falls outside the scope of the Declaratory Judgment Act. Now, this is awesome. This guy literally just gave us the kit and caboodle, right? Because this is what he did. Let's read it through. Declaratory judgment in the state of Florida is governed by Florida Statute, Chapter 86. Oh, thank you for serving up exactly which one we're going to address. And the grounds for which are spelled out in Florida statute. It states that the court may render declaratory judgment on, okay, the court, hold on, the court. Hold on, wait a minute, hold on, wait. Trial by jury. Oh no, we got a problem. See, this man believes that the court actually has power in this court. Sorry. On the existence or non-existence of any immunity, power, privilege, power, right? Or right. 2, of upon any fact upon which the existence of such immunity, power, privilege, or right does or may depend, whether such immunity, power, privilege, or right now exists or will arise in the future. Florida Statute 86.111. Okay, so remember what I said about legislation and facts versus, or legislation versus the people, right? So here's how it works, right? So you got the Declaration of Independence, and then you got the Constitution, right? Constitution. And then you got the Bill of Rights. Boom. American people. At common law. Right? And then, hold on, we're going to do this. We're going to do this the best way. Look, we're number 1. Yeah. We, number 1. Number 2, the birth child. Legislation. Codes. Acts. Statutes. Ordinances. What else? Regulations. And any other, now here's the kicker, legal doctrine. Does that make sense? See, this kid actually believes that you're supposed to have supposed to ask permission, because that's how funky this thing has gotten. Let's go on to page 3. All right, everybody enjoying this? I'm enjoying this. I love interpretation and analysis. I enjoy this. It's one of my favorite things to do. Is just pull stuff apart, and I'm glad I get to share it, and hopefully it'll get some premise on what's really going on around here. Okay, so upon motion to dismiss based on insufficiency to state cause of action. Again, here we are. Here we are. Your public officer has told you that unless we hurt you, or unless you have a monetary equitable grievance, you can't do anything. And we can just run around like tyrannical monsters, passing whatever rules, ordinances, policies, procedures, acts that are unconstitutional and against the Bill of Rights. And we'll call the police because we have all the power. I don't need a cause of action to command you. And that's what you're going to learn. All right, a well-pled. So declaratory relief, all well-pled allegations must be taken as true. Oh, wait, hold on. All well-pled allegations must be taken as true. Here's the problem. No allegation. It was just questions. So, irrelevant. Oh, by the way, here's our courts of, which aren't trial by jury. Test for sufficient complaint, declaratory judgment is not whether the plaintiff will succeed in upon. Oh, by the way, I've actually had cases with him. He loves this one. He seeks favoring his position, whether is entitled to declaratory declaration of rights. Whether he is entitled to declaration of rights. Whether he is entitled to declaration of rights. So, if you question whether you have rights under the Bill of Rights, they're saying that you're allowed to do this. Or are they not? Give me 1 second. I'm sorry.
Hey.
Hey, I'm recording right now. What's up?
Oh, sorry. You want me to let you go?
Yeah. Text.
Okay.
All right. Bye.
All right.
All right. Sorry about that. I had to take it. Didn't know if something was up. Okay. So Platt versus general development. That's funny because where I live, this is all old general development stuff. And actually, I know a guy in my town named Platt, which means this might be actually from my hometown. So, Florida Department. Here we go. Same thing. Dismissed. 1961. All right. Thus, active jurisdiction, the party is seeking a declaratory must show that he is in doubt as to the existence or non-existence of some right. So he's saying that, I don't even know, like this doesn't even make any sense, of some right, status, immunity, power, privilege that he is entitled. So he's saying that you can't get a declaratory judgment unless sorry, give me 1 second. I don't know how to pause this thing. Give me a second. Let's see here. I'm still learning how to use this. Oh, there we go. Stop. Hold on. Stop recording. Here. I don't know. Anyways, I'm gonna have to deal with that later because I want to finish this, and I still got a way to go. All right. So And again, look who he's talking about, right? So we're going to get back to this because I just want to finish it. So corporation, court of, and no trial by jury in any of this, right? So no facts have been determined. So he's citing all these cases, and they are no fact cases because these courts cannot determine a fact. That's pretty much what he's telling us. Okay, now here it gets even more interesting. Let's see what he goes. Petitioner makes a declaration of intangible public property right under the First, Fifth, and Seventh Amendments of the United States Constitution. Actually, it's Constitution 4. It's supposed to be Constitution because the people made it, right? 4. Hold on. 4. The U.S. of America. Remember what I told you about words? Vocabulary? Yes. So this thing right here doesn't exist. This Constitution for the United States of America. Of means slave. America means people. U.S. is the birth child with no father, only a mother because it came to Earth, and Earth is Mother Earth, right? Boom, boom. There you go. 4. So the people said, here is your Constitution. You were constituted. And the Constitution was called, the birth child was called the U.S. on Earth. 10 by 10 square. Washington. Because that's pretty much where the United States lives. That's the only place that the United States lives. Okay. Could potentially be violated. Could potentially, all right, and then look, there's no mention of what this intangible public property right is. That actually is the Bill of Rights. Of rights. Rights. Which is the First, Fifth, and Seventh Amendments. Want some gum dum dum. But he has no idea. He has no idea because he went to an equity law school and never learned about individual rights at common law. In breaking down each of the amendments, we find there's no mention of violations. So he still thinks you have to be violated to command in governance, your government. He still doesn't understand. He's telling you, if we break it, you can say something. If we don't, shut up. And this kid's about 20 years old telling a 50-year-old man to shut up because the people are destroying his private road and they don't want to do anything. So there are no allegations. Petitioner's First Amendment right to redress government were violated. So again, he still thinks we're talking about reparation. He's saying it. He's literally telling us exactly what he's saying. If you can listen. True. That doesn't mean I can't command you or the jury can't command you. I can't command anybody. I can just ask the jury if they want to command you. So there's no mention of how the petitioner's rights are in question. Yes, you're right, because this is an exercise of right. Of right. See, remember the slave part? The right has the power to exercise because it's of right. Exercise of right. Aristotle. Of means slave. Even in the petition, it is mentioned that they have made redress with the government. See complaint, section B. There is no mention of any government, any county government not allowing a petition to be made to it. apparently has no idea that here, let me help him. This case is the petition. That's right. This is the petition. The one you're trying to get dismissed. All right. Good. Okay. Let's go on to page 4. Here we go. Made and accepted by the county government. Okay, so here's what's funny. So, made and accepted by the county government. So what he's actually saying is, unless you go cry to them so they can mock you and ignore you, you're not allowed to say anything. And what he doesn't understand at common law is county court of fact. This is where it happens. We've been going to the administrative state before we went and got the facts, which is why they've been running rampant all over us and why we've been getting our butts kicked. Does that make sense? I hope it does. So the First Amendment guarantees, thanks for telling me, it guarantees the right to petition the government. Yes. Yes. So look, here we go. You ready? Right. Here we go. You have the petitioner, right? And you have the defendant, which we're going to call Charlotte County. And this is the petitioner. And then this is the court, right? And everything that goes into a court is either a complaint or what? A petition. Do you know why it's a petition or a complaint? Do you know why it has to go to the court? Because even if they don't respond, look at that, through the court, right through the court, boom. And then you've been summoned. This is called, when you petition them and then you summon them, this is called proper service. Proper service, right, is petition and summons. Must be summoned by the sheriff. Isn't that interesting? Must be summoned by the sheriff. Why? Because the sheriff works for the judiciary. That's right. Check your statutes. The sheriff works for the court to protect and serve. What does that mean? Protect the peace. No rioting. Serve writs, warrants, and summons. Summons. Yep, that's what serve means. Doesn't mean to serve you. It means to serve those. And sheriffs are found under the judicial branch. Go check it out. That's the way it works. So, additionally, the relief sought by the petitioners not go toward confirming the existence or non-existence redress process. The grievance is the redress. It is to, and here it is right here, the preamble, ensure domestic tranquility. Tranquility means there can't be controversy. Secure the blessings of liberty. Liberty. That's right. How? By telling the public representatives what they are going to do. All right. There is no allegation that the Fifth Amendment right due process was violated. He still thinks this is for redress, or he still thinks this is for reparation. Only there's been no money asked for. No reparation. What's going to be reparation is when this dude loses his job and gets a restraining order because he's ignorant and breaking the law. Not the statute, not the ordinance, the law. Okay, Fifth Amendment guarantees due process in criminal cases. Hold on. Hold up. Wait a minute. Let me put my 2 cents in it. What? Did he just say that? Did he just say that? Hold on. Let's see what this says. Fifth Amendment. Fifth Amendment. Hey, we're going to pull it right out of the Library of Congress. Oh, hold on. Here we go. Let's roll it in. We're going to roll this bad boy in. Boom, shagalaga. Look at that. Here we go. No person shall be held to answer for capital or otherwise infamous crime. Just so you know, capital crime means murder. Infamous crime means felony. Unless in a presentment or indictment of a grand jury. We're going to talk about that later. Except in cases the militia twice compelled in a crime. Nor be deprived of life, liberty, and property without due process of law. Hold on. See this? See this part right here? Look, I want to make sure I get it right. Make sure everybody sees it. Look, see this? Life, liberty, or property. Property has nothing to do with criminal. Property has to do with property. Look, nor shall private property be taken for public use. Well, what does that have to do with the crime? Without just compensation. Look at this. What does that have to do with crime? Nothing. It has nothing to do with a crime. So, we go back and we go dumb. Because this whole area, I guess he didn't read all the way to the end. We're going to go with a downspout on this one for Tiernan Cole. All right. Maybe you should read the thing. You're supposed to be a lawyer. No, you're not. You're an attorney. I forgot. Equity. It's all about equity. It's all about money. He sold his soul to power and money. He's no longer part of the American people. He is against us. There has been a violation or claim of violation of the petitioner's 7th Amendment right to trial by a jury. This actually is stupid. I mean, like I can't even get past the stupid in it. Okay, so wait. There has been, so he's saying someone violated his right to trial by jury or claim of violation. I think this dude needs to learn how to leave. Needs to learn how to read. Okay, let me show you why. I'll bust this out, right? So we're gonna bust this bad boy out. We're gonna make it real. I didn't prep for this, but since it's in here, we're gonna talk about it. All right, so we'll bust this, and we're gonna head on down to here. Oh no, wait, wrong page. Because you're gonna want to see this. This is gonna be interesting. I believe this will be interesting. All right, here we go. Florida rules, common law procedure, going down to rule 31. All right, boom. Is this common law? Yep, 31. I believe that's the rule. 35. Oh, that was it. Boom. Okay, so let me see something. The clown, right? Clown boy, clown attorney says there has been a violation or claim of violation of petitioner's 7th Amendment right. Discusses circumstances for jury trial. Okay, first of all, because it's an action at law, and because we are operating at the rules of common law, wrong. Rights reserved. The right to trial by jury is declared by the Constitution or by statute, shall be preserved inviolate. Demand. Any party may demand a trial by jury of any issue triable of the right by jury by serving upon the other party a demand, therefore, in writing at any time after the commencement of the action and not later than 10 days after the service of pleading directed as such issue. Such demand may be endorsed upon the pleading of the party. Special issues. If his demand, a party may specifically specify the issues which he wishes tried. Otherwise, he shall be deemed to have demanded trial by jury. Otherwise, here's your default, right? He shall be deemed to have demanded trial by jury for all issues. So triable. If he demanded a trial by jury for only some. Okay. So now let's get back to attorney. Let's put the attorney back on the block. All right, he's on the block. Number one, he asked for a jury trial. Wrong. Didn't ask for a jury trial. He asked for a trial by jury. By jury. There you go. Trial by jury. Woo. There you go. Okay. So this is wrong. This is wrong. Okay. And the right to a jury trial is not in question at any point. Now, the reason he's using the word jury trial is because this comes from equity. It comes from the rules of civil procedure, not the rules of common law. Two different words, two different meanings. Verse, trial by jury. There you go. Boom. As in the 7th Amendment. Okay? Jury trial happens at the end, once they get all the preliminaries done. At equity. All right? This is for all issues. Why is it for all issues? Because back in the 1300s, they realized if your judges are corrupt, remove them. You want to know how we know that? Hold on. Hold up. Wait a minute. Let me put my 2 cents in it. I like turtles also, so you know. So how do we know that that's what they're saying? Well, it just so happens that we have an opportunity to look into the reason for trial by jury. And here it is. Okay. Federalist Paper 81. You see that? I don't think you can see it. Well, I'll read it to you since I don't think you can see it. Oh, you know what? Stop share. I'll pull this over. Let me hit share. I want you to see this because I think this is important. Here we go. There you are. Now you're on this one. Boom. All right. So, Federalist Paper 81, Alexander Hamilton. The further review of the Judicial Department in relation to the distribution's authority. Some well-intended men in the state deriving their notions from the language and the forms obtained and the courts have been introduced to consider as implied supersedure of trial by jury in favor of civil law mode of trial. Civil law mode of trial, right? Civil law mode of trial. Boom. Which prevails in our courts of admiralty, probate, and chancery. Oh, look at that. Civil law mode of trial, which prevails in our courts of admiralty. Look, I actually didn't even make this stuff up. So, but it does not follow that the reexamination of a fact once asserted by a jury. Oh no, this actually ties everything together. Will be permitted to the Supreme Court. Why may it not be said with the strictest propriety when the writ of error is brought from the inferior to a jurisdiction superior court of law in this state, that the latter has not the fact, but it takes cognizance of it as it appears upon the record and pronounce the law arising upon it. This is jurisdiction of both fact and law, nor is it even possible to separate them through the common law courts. Through the common law courts of this state ascertain disputed facts by a jury. Disputed facts by a jury. Yet they unquestionably have jurisdiction over both fact and law. And according, when the former agreed in pleadings, they have no recourse to a jury. But no recourse, look at that, no recourse to a jury, but proceed at once to judgment. I contend, therefore, on the ground as that the expressions appellate jurisdiction, both as to law and fact, do not necessarily imply reexamination in the Supreme Court of facts decided by juries of inferior courts. Juries, facts, juries. Hear this? This is because the Constitution was written at common law. So we can go down even further. Here we go. This for appeals, observation, judicial department. 83. The objection to the plan of the convention, which is met with success in the state relative to one constitutional provision for trial by jury in civil cases. The mere silence of the Constitution in regard to civil cases is represented as an abolition of the trial by jury, and the declamations to which it has afforded a pretext are artfully calculated to induce a persuasion that is pretended abolition to complete the universal extending not only to every species of civil, but even to criminal causes, civil and criminal. To argue with respect to the latter, it would be vain and fruitless as to attempt to demonstrate any of those propositions to their own internal evidence, force conviction with the express in language, adapt and convey their meaning. Okay, so let's get to the meat and potatoes because I don't want to keep going through this. In courts of common law only, the trial by jury prevails, and this with some exceptions. In all others, a single judge presides and proceeds in general either according to the course of the canon or civil law, without injury. The ancient mode of trial by jury is one of the best securities of rights of the people and ought to remain sacred and inviolable. That's funny because that's what was read in the demand for jury trial. And I'm going to go back to that because apparently you guys didn't see it, which I didn't realize. So there you go. Okay. And that was in Federalist Paper 83 by Alexander Hamilton. Okay. So anti-Federalist papers. Now remember, this is Thomas Paine and Patrick Henry. the farmer. Page 258. The ancient mode of trial by jury is one of the best securities of rights of the people and ought to remain sacred and inviolable. The only answer that can be given is that there are implied in the general powers granted with equal truth that it may be said that all the powers which the Bill of Rights guard against and the abuse of are contained or implied in the general ones granted by this Constitution. This Constitution and the laws of the United States shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby anything in the Constitution or laws of any state to the contrary notwithstanding. All right? That makes sense? All right, good. So we're going to stop the share. We're going to bounce back here. I know this is still going, but I think this is important. And I think breaking this down is actually going to do some good. Oh, hold on. I wanted to bounce back and at least show you the demand for jury trial because I read it, but I didn't realize it didn't pop up. So let's go over to this. There we go. This is your demand for jury trial, right? Boom, 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 boom. We're looking right here. In his demand, the party may specifically time he serves the. It's right there. I know it's right there. Oh, here we go. Otherwise, he shall. Otherwise, here's the otherwise. Otherwise, notice the new sentence or a comma, whichever one you want. All right. Boom. Right there. Otherwise, he shall be deemed to have demanded jury trial by jury for all issues so triable. All issues. That means if there's a decision that has to be made and you demanded a trial by jury, judges don't make any decisions. That's the way this ball bounces. All right, so let's bounce back over here and let's rip this thing apart. So back on screen one. Hope you guys are enjoying this. I like teaching, so we'll keep on going. Keep on trucking. Oh, look at that. Look at that thing. Hold on. Let's get out of here. No, not looking for that. Looking for that. Okay. So let's finish this bad boy up. Page 4. So petitioner makes no mention. The whole thing is one big right. And no assertion of property rights of the road. Doesn't matter. You're asking a question. Petitioner is not entitled to declaratory judgment at common law. Either has been no violation of rights. He still thinks that you can't command your government because whatever clown thing you come up with. So petitioner further states that they're bringing suit at common law, which, oh, there he goes. He actually admits it. So here we are. Boom. Let's get him. Let's get him. Get him. All right. So states, that's a declaration, right? I'm glad he heard it. I'm glad he heard it was declared. So this is a declaration. All right. At common law. At common law, right? Ooh, doggy. Now look at this. This is awesome. He actually knows it. Presumably attempting to avoid the declaratory. What did he do? What did he say? Because remember, they'll tell you all their dumb. All their dumb will come out if you just listen to what they're saying. Here we go. Let's get some dumb. Want some gum? All right, here we go. Declaratory Judgment Act. That's right. That's right. The guy that gets paid public funds and swore an oath actually knows that you can go around their acts when you are at common law Isn't that amazing? He actually just admitted it. He also admitted that there's a whole lot of treason going on in the United States because these acts they're not for us. They're authorizations for them to use our stuff. The petition does not give a case for enacting at common law. Does not give a case for enacting at common law, as the common law rule for declaratory judgments requires that right has to be violated. This is about as dumb as you can actually get. So what he's saying is, in my brain, the people who work in government have all the power and everyone else is a slave. Oops, sorry. That's an L. Yes, that's what that says. Requires. Declaration of Rights requires that right has been violated. Well, then, here's the question. How do we instruct them? Lawfully. How do we instruct our government lawfully? Interesting. So the goal of the Declaratory Judgment Act, so now he has moved this entire thing onto the Declaratory Judgment Act, are to relieve litigants of the common law. Hold on, what's it say? Look at this. Relieve litigants of the common law rule that a declaratory judgment of rights cannot be adjudicated unless the right has been violated, and render. Oh no, look at that. Our wise and intelligent legislators, literally, he just admitted, they circumvented the common law, or at least they tried. I would call that treason. Common law. Oh no. Oh no. They will tell you. Oh, for those of you like cursive, I've been practicing. It's been a long time. So, and render practical help ending the controversies. Help ending controversies which have not reached the stage where other, hold on, legal relief is immediately, but we didn't ask for legal relief. We asked a question to the people. That's all. Oh, look, and associated independence. Bell, corporations. What do corporations have to do with the people? We are all just corporations. We're all in the yellow submarine too, by the way. This dude, apparently he believes he is the yellow submarine. Okay, moving on. So we get back. Let's see. We're gonna hit up some more equity cases that have nothing to do with this thing, right? So, oh, don't you run away yet. We're going right here. Boom. All right. So, got some more equity cases. To operate within this sphere, well, I like the word sphere, right? It means infinity, right? Because that's a whole geometry philosophy thing. Anticipatory, a sphere of of awaiting, and preventative justice. Preventative justice. You mean to protect? The Declaratory Judgment Act should be liberally construed. Sorry, this is an action at law to find a fact and instruct government. He can keep his act because it's an act. I think they call it acts because they're acting. So, all right. In order for a claim of declaratory judgment to continue at common law, there needs to have been a violation of a right where declaratory judgment act. Here we are. Wrong court. There needs to be either an actual violation, potential violation, and there's no allegation of any violation. That's because we asked a question to determine a fact so that we can create a common law, the people's law, and instruct you. Fascinating. And now he's presumed himself to be in the Declaratory Judgment Act. And apparently he moved us out of common law into legislative law. And now he just keeps going on about how the act thus may bring such action. So now he's telling you're not even allowed to petition. Nope, can't bring, no petitioning. Cannot be brought. Look, petition cannot be brought for declaratory judgment under the Declaratory Judgment Act. Hold on. Wait a minute. Hold on. Here, let me help you. Dum-dum. Common law is not the act. Does not meet the requirements under the common law. Now this is funny. Common law rule to be brought either. Where did he cite a common law case? Because remember, common law is not legislative law. Common law is laws made by trials by jury for self-governance to create local community law or county law. So he's talking about statutes. He's talking about civil rules of procedure. He's talking about acts. He actually believes these things all mean common law because he's only been trained in legalese. He knows nothing about common law because he got out of high school without learning it. So, oh, sorry, hold on. There we go. And we're back. All right, here we go. So section F, questions to court. Yeah, because we're trying to get some questions. Seeking answers. These three questions regard the status of Prada Street, and the final one is answered by looking to Florida statute. Hold on. Here. Let's. Okay, so let's put it. I'm having fun with this. I enjoy it, and I have a bit of sarcasm. Okay, so let's try this. Okay, first there was a Declaration of Independence. Then there was a Constitution. Then there was a Bill of Rights. Then there was a state constitution. Then Constitution, right? Constitution, right? Actually, that's not true. Let's correct that. That's not what happened. There wasn't a state constitution yet. Before that, there was territory. law. Uh-oh. What's territory law? Those are the common law trial by jury laws that were found by those people that live there. They equate to these three bad boys right here. And then there was a request to enter the Union or the United States. And then there was a state constitution, because remember the ratification, right? Boom. And then there were acts. And then there were statutes. So, common law is over here. It includes these. And actually, it actually does include these. So, there you go. Boom, boom. All right, cool. This is equity. Uh-oh, got a problem. Which one came first? Chicken or the egg? All right, all right, all right. Here we go. Moving on to page 6. Oh, I hope you guys are enjoying this. I'm enjoying it, and I like doing this stuff. It's kind of fun. Page 6. Rolling. All right. So, 3 advisory opinions from the court. From the court. But guess what it's not from? Ready? It's not from a jury. Trial by jury. For what? Oh, yeah, fact. That's right. Which are not authorized under the Declaratory Judgment Act. Again, wrong rule. It was settled that Florida courts will not render. Yes, I know, because the people have all the power. In a form of declaratory judgment, what amounts to advisory opinion. Look, he's even saying it. I love it. At an instance of the parties who show merely the possibility of legal injury. Legal. We're not dealing in legal. We're dealing in law. There you go. And this is not a possibility. This is a command. Oh no, look at that. Command on the basis of hypothetical state of facts. Yes, because we are going to get the facts. Hypothetical state of facts. They're all hypothetical state of facts because they're opinions. But we're going to get one of these bad boys to give us one of those bad boys. And then that bad boy is going to go over here. And there ain't going to be hypothetical. There's just going to be a fact. And the facts will reign because God is the truth. And the truth will set you free. Not arisen, only contingent, uncertain, or in rest of the future. There you go. Thank you. Okay. I like turtles. So, power allowed declaratory judgment proceeds as a vehicle to obtain advisory opinions. A vehicle to obtain advisory opinions. That is true. That is true. It is declaratory judgment. And a vehicle to obtain advisory opinions. Except it is going to be a trial by jury. And when the jury says it won't be advisory, it'll be commanding. Fact. And we can take your equity case out of here because there's no jury involved. Florida courts will not render in the form of declaratory judgment. Well, we appreciate the court not trying to render anything. So, good. Stay in your lane. Your lane. Bye. Okay. Advisory opinion. Duh. Okay. Look, here we go. Show merely the possibility of a legal injury. Too bad this is a lawful command. Case law is clear. Whose case law? Oh, you mean case text? You know, as someone who's spent enough time in case text. Bless me. Thank you. Okay. Someone who spent enough time in case text, in case law. Not common law of fact. Does not allow for the issuance of advisory opinions. We agree. Specifically, in such cases, no controversy where there exists a bona fide dispute. We agree. For this reason as well, the petition should be dismissed. Dismissing this petition would actually violate the petitioner's First Amendment right at common law. Here, it is somewhat better. Boom. Okay. Petitioner's questions can be answered by county records. What? So apparently, county records have the power to create a law and determine a fact. And by Florida statutes. So statutes are not law of the county. Besides, Charlotte County government doesn't even follow any laws, or at least very few of them, only the ones that make them feel better and the ones they want to use when they want to use them. Other than that, they don't obey really anything. So how exactly? So what he's saying is the petitioner can obey the law so the petitioner is the slave. Charlotte County is king because they say they command the slave. And the Bill of Rights doesn't exist. Hope. All right. Hope. Stop. Sorry. Package delivery. All right. So. Let's get to the next one. 2 pages to go. It's getting tiring. We're going to start going a little quicker because I keep repeating myself. So, petitioner lacks standing to bring suits of declaratory judgment. Well, not a suit. Called an action at law. Law. Action at law. Don't need standing because you got a Bill of Rights. Bona fide dispute. I mean, it's like he just repeats himself. It's like babble. The law is clear. The law is clear. The law is clear. Well, that's a problem. It's a problem that he actually thinks that that's the law. That's not a law. That is a act or a statute for slaves. We call those slaves public officers. They're his laws that he's supposed to obey. And instead he's trying to force them onto us as if we're supposed to obey. We're not supposed to obey. We're supposed to command. We just haven't been commanding. All right, so here we go. I bring action, the plaintiff must allege, not a plaintiff. It's a petitioner. right? We are petitioning. Wrong word. Bad. Who has suffered. Doesn't need to suffer. This is about command. Constitutional grounds based directly upon the legislature's taxing or spending. Wrong court. Right? Here we go. Equity court. Anyone want to know why the rules of procedure, the rules of common law procedure, it says that there's supposed to be a separate clerk docket for common law? Because whatever the trial by jury decides, that's now the law in that county and could become the law of the state because the people commanded it. Petitioners claim that they have standing based upon being a taxpayer within the Charlotte County. However, simply being a taxpayer does not entitle one to standing. So look at that. They'll take your money and you still don't have any rights unless they say so or some judge says so. Government taxing measure, expenditure violates specific constitutional limitations. Yeah, there you go. Look, he's actually telling you everything you need to know. All right, we're going to close this off. We got 2 pages to go. So, there's no mention of anything in the lines given no special claim of violation, taxing spending power, constitutional, or even a claim of dispute. The petitioner does not have standing to bring declaratory judgment against the county. The county is not getting their public records done. So the petition for a declaratory judgment must be dismissed on 3 primary reasons. Failed to dispute exists between the county any rights, powers, immunities, or privileges of the petitioner regarding the road. That's not true. And that'll come out in the hearing. He actually spent $3,000 that Charlotte County government defrauded him out of, that he will now have to seek reparation once he gets the facts. Second, the petitioner is seeking advisory opinions. No. He is seeking a fact. The court regarding status of the road and the function of Florida statutes. Don't really care about Florida statutes. We supersede those. Need to be dismissed. The petitioner lacks standing to bring declaratory action based solely on being a taxpayer. Well, he's not bringing it solely on being a taxpayer. He just stated that he pays taxes. He is an American person. In order to continue, the petitioner needs to bring forth the bona fide conflict between themselves and Charlotte County. For this reasons, petition needs to be dismissed. There you go. This is your public officer, agent, attorney who is waging war against the people in a function of clandestine warfare. Right here. There you go. War against the people. In a function of judicial clandestine warfare. Doing everything he can to deprive you of your inalienable right to petition your government for redress of grievance. and we wonder where the chaos comes from. God bless. Have a nice day. Stop sharing. All right, everybody. I hope that you enjoyed this this presentation. I hope that this was interesting, and if you have any questions, reach out. I'll be happy to try and answer. Maybe I can do some other ones if you want to talk about something else. Have a good day.